Hi, Rodney Rouzan here. Welcome back to Wars 101. And today I'm going to be going over a lawsuit, and it's a malpractice lawsuit against a previous attorney that I had hired when I was previously wrongfully terminated from my career with the LAXPD. I hired this attorney to go after the city basically for Labor Code 1102.5, which is the whistleblowing statute. So she was hired, didn't file the government claim timely, and then withdrew herself from the case. So that basically, by not filing that government claim, I lost my right to bring the 1102.5 claim for the whistleblowing, and it damaged a lot of my possibilities of and my claims against the city of Los Angeles. So then at that point, due to the what has occurred, I've opened up a malpractice lawsuit at the Stanley Mosque courthouse in the Los Angeles Superior Court. So that's where it stands right now. She's being served probably tomorrow, and then she will have 30 days to respond. So her name is Vivian Fell, and she's from the Fell Law Group. And so yeah, that's pretty much what's going on with that case. Then I also, in this series right here, I have a FEHA complaint, the Fair Employment and Housing Act. I'll be going over that next as well. And then I also have another claim against multiple members of the LAXPD and the city and the Los Angeles World Airports, and that's a rights violation in the federal court downtown Los Angeles. So I'm going to be going over each one of these, and what I want to do is just show individuals how this process works. It's a lot that's gone into it. Times have really changed. I've been doing this for many years, and now with the invention of AI and using all the different projects and workflows and agents and creating all of this and creating the proper timelines, I believe now is a great time when pro per litigants can actually be almost on even playing ground with the attorneys and have the proper resources to organize a case. So I'm going to be showing you exactly how I'm organizing the case. So this first one right here, like I said, is with Vivian Fell. And so go ahead, and I hope you enjoy the video.
All right, let's dive right into this explainer. I'm Rodney Rouzan, and today I'm walking you through my own personal David versus Goliath story. You know, we often place complete trust in legal professionals, right? But today, we're going to examine exactly what happens when the very lawyers you hired to protect your rights completely drop the ball. And more importantly, how you can stand up and fight back. We're looking at a real-world legal malpractice lawsuit that I filed in pro per, which basically means I'm taking the wheel and representing myself. This is a fight for accountability, and I'm going to show you the evidence, the strategy, and the mechanics, step by step. We'll be breaking this journey down into 4 really straightforward steps: what happened, the lawsuit itself, the process of executing it, and finally, the bigger picture. So, let's get right to it. Section 1. What happened? The whistleblower's stand. To really understand this, we have to look back at my time as a sworn public safety officer for Los Angeles World Airports. I blew the whistle on authorized COVID-19 compliance forms, and instead of an investigation, well, I faced severe retaliation and was ultimately terminated in March of 2024. Naturally, I promptly hired Fell Law to protect my rights, but then they missed a critical, totally non-negotiable deadline in October 2024, and astoundingly, it wasn't until June of 2025 that the firm finally admitted their error. Now, the absolute crucial point here is understanding this specific deadline. Under California law, you have a strict 6-month window to formally notify a government entity that you're suing them for money damages. It's called a government tort claim deadline, and it is literally the key to the courthouse door. By missing that October 11th cutoff, my attorneys essentially vaporized my underlying $2.8 million damages claim against the city. A highly valuable case was just gone entirely because of a missed date on a calendar. The smoking gun for this professional negligence finally showed up on June 3rd, 2025. I received a written admission from the founder of the firm, Vivian Fell, basically stating, "I write to advise that I believe I must withdraw from your case based on statutory government tort claim deadlines." Just like that, a highly valuable case was permanently barred. Which brings us to Section 2, the lawsuit. 6 causes of action.
Because my attorneys failed to preserve my claims, I filed legal malpractice case number 26 STCV 17285. And the dynamic here, it is purely David versus Goliath. As the plaintiff, I am pursuing this case completely in pro per, which just means I'm a citizen confidently representing myself. On the other side, my opponents are an established corporate law firm, Fell Law, PC, and Bibion Fell. Taking out a giant like that requires immense focus and absolutely strict adherence to the factual record. In my first amended complaint, I laid out 6 clear causes of action. If we strip away all the heavy legalese, it really boils down to this: severe professional negligence for missing that hard deadline, broken trust and fraud for actively hiding that error from me, breach of contract, and ultimately the firm's ongoing refusal to return my own property and files. And that leads to a pretty glaring question. Why is an established law firm withholding a financial expert's files? Honestly, one of the most egregious issues in this whole lawsuit is conversion. The defendants have continuously refused to hand over my complete client file, specifically the damages analysis prepared by financial experts at Stout Recius Ross. These are materials generated for my case, documenting my financial losses, and yet they remain stubbornly withheld by the firm. Because the underlying whistleblower claim had such substantial value, we're estimating well over $2.8 million in lost wages and damages. This malpractice suit is filed as an unlimited civil case. That simply means we're demanding damages that well exceed the court's $35,000 threshold for unlimited jurisdiction. The financial stakes here are incredibly high, and they were lost purely due to the firm's negligence. Let's move on to Section 3, the process. Executing the lawsuit. Now, I want to demystify how a pro per litigant actually executes a lawsuit like this out in the real world. Honestly, there's no magic to the legal process, just strict adherence to the rules. Step 1, I successfully e-filed the complaint. Step 2, I initiated a strategic plan for service of process. And Step 3, meticulous preparation for the upcoming case management conference. Let's actually look a little closer at Step 2. To ensure an airtight case right out of the gate, I wasn't going to leave anything to chance. I instructed process servers to simultaneously hit 2 different addresses well before the court's deadline. We targeted Bibion Fell personally, and at the exact same time served the firm's corporate agent at a completely separate address. This dual-track approach guarantees everyone is officially on the hook, leaving 0 room for evasion. So all of this careful preparation leads directly to the Case Management Conference, or CMC. This critical milestone is set for October 6, 2026 at 8:30 a.m. in Department 311 before the Honorable Doreen B. Boxer. The CMC is essentially the first major scheduling meeting with the judge, where we'll set the roadmap for discovery, the exchange of expert witness information, and ultimately lock in that trial date. And to further demonstrate my strict adherence to the court's rules, alongside the summons and complaint, I also served the mandatory alternative dispute resolution package. Showing the court I'm following all mandates is huge, and that includes notifying the defendants of options for free virtual settlement conferences through programs like Resolve Law LA. When you're in pro per, you have to cross every T and dot every I, proving you're just as thorough as, if not more thorough than, opposing counsel. Finally, Section 4, the bigger picture, a demand for accountability. This specific lawsuit really builds into a much larger and honestly super necessary conversation about trust. Like I alleged in my complaint, this case isn't just about a missed date on a calendar. The evidence indicates the firm actually recognized the missed deadline internally in April 2025, but they actively placed their own interests ahead of mine by concealing it until June. That critical delay prevented me from seeking timely corrective action that might have actually saved the case. So I'll leave you with this final provocative thought. If the justice system requires absolute, strict adherence to deadlines for everyday citizens, shouldn't attorneys, the highly paid experts we swear to protect our rights, be held to the exact same standard of accountability? When those we hire fail us and try to sweep it under the rug, taking a calm, factual, and resolute stand in pro per might just be the most powerful way to demand true accountability. Thank you for joining me on this explainer. I hope this inside look into the mechanics of a real malpractice suit empowers you to understand your own rights and inspires you to stand up when you know you're right.
So now that you see, like the Fell, they've been, after they get the service, they have 30 days to basically respond. I'm going to put the whole lawsuit into the link, so you'll be able to see the whole lawsuit, what exactly was sent, and then as I start getting responses to this lawsuit, I'll be updating everybody and showing exactly how they're responding and what they respond with. I expect a demur, and that's where they kind of like narrow the issues. There's 6 causes of action right now. I'm pretty sure they're trying to narrow some of the issues or even try to knock the whole case out. So I'm going to take you through that whole process. So like and subscribe, and I'll see you guys in the next video. Peace.
Words in papers, words in books, words on TV, words for books, words of comfort, words of ease, words to make the fighting cease. Eat your words, but don't go hungry. Words have always nearly hung me. Words are stupid, words are fun. Words can put you on the run. Concrete words, abstract words, words to tell you what to do. Words can put you on the run.